I'm Mark Fletcher. I'm a PhD student at the ANU School of Politics and International Relations in the Research School of Social Sciences, and I study the public understanding of law. This video provides a quick update on some methods I've been using in case somebody else out in the wide world of empirical legal studies is also battling the same demons. As a very short introduction to my PhD thesis, I'm exploring the extent to which telecommunications interception legislation is congruent with public opinion. It's part of a broader area of research about how we develop national security law with public servants imagining that they know what the average person thinks is reasonable, and the public at large discussing legislative reform armed with pretty bad legal intuitions. There already exists some very sophisticated ways to measure the public understanding of law, often in terms of true knowledge, which I am not really all that interested in, but also in terms of what they think a reasonable legal outcome is. These areas of law tend to be criminal law and garden variety private law. Very little of the existing research is able to be adapted to national security law, where the law is very remote and there is little contact. The major part of the project is comparative, looking at Australia, the UK and Canada, 3 of the Five Eyes countries. But along with my thesis, I also have other research projects on the side, some of which intersect very clearly with my thesis, some that are a little bit more of a stretch. One of the problems of doing interdisciplinary research is making sure that you remain credible in both areas of study. So this video originates with my research on defamation law, examining public intuitions about defamation law and seeing if the intuitions match reality. One section of the public is really, really clear in its intuitions about defamation law, specifically media professionals. You can get a lot of statements from social media by journalists about how they think defamation law works, which is usually not terribly accurate. You can also get media companies themselves making statements about how they think defamation law affects journalism. And these usually contain a lot of falsifiable statements, claims that we can test to see if they might match reality. For the pilot project I've done, I used some claims made by the Media, Entertainment and Arts Alliance and found that, surprise, a lot of their claims weren't supported by evidence. So what I wanted to do was take that pilot study, correct some trivial errors, but also use the study to develop some other theories about what influences outcomes in defamation law. There were obvious opportunities to make the study a bit beefier, answering a wider scope of questions. And although the pilot was run in Stata, for the beefier project, I moved to R. Why? Because R is magical and wonderful in every way, especially with such a large community developing packages that standardize irritating tasks and computations. I also learnt Python as a child and will never return to it. I wanted my code to be a bit more sleek. I wanted it to select the sample of cases, read them into R in a way that computations could be performed, and then for it to give me some results. What I quickly learned was that my problem was in 2 parts. On the one hand, what I wanted was the ability to get legal data extremely quickly, data in. And then, on the other hand, I wanted the program to make some decisions about what was signal and what was noise, apply some statistical methods, and then pump out some intelligent comments. So I named these 2 parts on a pun, obiter and dicta. And you might ask, what do you mean by intelligent? Well, the most important thing in law is meaning, and this can be often quite difficult to quantify, and can also be difficult for people who aren't legally trained. See, for example, the recent discussion about whether quarantine is a Commonwealth responsibility based on folksy readings of Section 51 of the Constitution. but it's also doctrinal analysis that tells us what questions are worth answering. I tend to find analyses of the length of judgments to be pretty boring, but big data should be able to give us some interesting insights into whether particular terms or phrases are being used more in judgments, if those terms have changed meaning, or what changes the use of particular terms and phrases. This can give us some insight into how judicial reasoning has changed over some period of time, or the peculiar influence of a certain judge over a period of time, etc., etc. But most importantly, doctrinal analysis helps ward off idiot errors, such as thinking that a legal term, death recorded, meant that the death penalty had been carried out. A really good example of this in my recent work is a legal term that appears in the reports of a statutory body that also have a separate non-legal meaning. And before I could sort of apply the statistical method, I needed to untangle the legally interesting phrase from the ordinary English phrase. And there are a number of reasons to think that this process should work. Legal decisions are extremely regular in the sort of information that they contain. There are parties, usually plaintiff and defendant. There's the names of the lawyers, which can be interesting, the orders that are made, the judge or judges making the decision, whether it's an appeal or not, etc., etc., etc. If you know where to look in a judgment, you'll find the answer to the question. More importantly, judgments have these catchwords which make it really, really easy to categorize decisions and automate information collected about them. There is some level of variation, but individual courts tend to be fairly consistent in how they use the catchwords. And data is plentiful and easy to get. Legal databases try their very best to give you the information that you need. However, there are a lot of problems. Different jurisdictions have different formats, for example. So if I teach Obadard to read decisions from the Supreme Court of Western Australia, it's not going to be able to find information from the Supreme Court of South Australia's decisions. Even something as simple as the citation is a pain in the arse. Obadard has to look in 2 places for the complete information from South Australia. Further, databases appear to be resistant to having information scraped directly from them. This is a rather famous recent decision from Jade, but if you look at the HTML tags to point in the direction of information, you find there often aren't unique tags for similar sets of information. Here, the Federal Court of Australia has the same HTML marker as the name of the decision, the name of the judge, the main catchword, and if you've noticed that they're all in bold font, that's a bit of a hint for what's going on. For all the obstacles, there's still stuff that I can do. I can get a list of cases that are very, very likely to be relevant to defamation law, and from that list pull a random sample for which I then manually drop in data. And the answering questions and printing results is crazy easy. So that's where I'm up to. If you're interested in more of my work, I'm on Twitter at Legal Reasoning, and I also have a GitHub for this project. Bye.